the draft, there are 3 points that we are going to discuss today on the draft bill. The awareness on the background of the bill, where the bill stems from, and its genesis, and then also look at what the draft regulation will exempt SMMEs on, and also we'll have a discussion on the implication for Office of the Chief Procurement Officer and us as the supply chain management professionals. You can go down, scroll down. I'm trying to hit the button from my side. As we all know that the Minister or the Competition Commission, which is an entity of Department of Trade and Industry and Competition, commissioned a study regarding the concentrations, and this study also came with the recommendation that there must be a bill that we're discussing today on the block exemptions of the SMMEs. Now, the draft block exemption regulation is to exempt categories of agreements or practices by the small medium enterprises from section 4.1 and section 5.1 of the Competition Act, Act 89 of 1998. Now this study, which was commissioned by the Competition Commission, measuring concentration and participation in the South African economy, has come up with the levels and trends that shows that the share of SMEs of South Africa's aggregate income is comparatively low and declining. Some of you who've got a background in economics, you'll understand what is the market concentration, and how to calculate the market concentrations and so forth, Now, they've made a study in terms of various industries. And we look in terms of what the study has revealed insofar as each and every industry that the study was undertaken on. Firstly, we'll look at the industry concentration regarding the infrastructure, and then we'll move to energy. We'll also look at the definition of various definitions of the SMMEs. Thanks, Prof. Now, this is an excerpt from the Competition Commission report on infrastructure. Firstly, we look at the infrastructure. The study has revealed that in terms of the infrastructure, there are many firms that enter the business rescue or exit the industry, with just 3 firms having a dominance which account for 70% or more of civil and major building contracts valued at over 200 million in 2019. As you might be aware that in 2019, what happened was that there were the grade 9s, I think just 3 firms which you can get on grade 9 if you go to, or if you have gone into the CIB register then. And these companies account for 70% or more. In steel, the top 3 producers supplied over 70% of steel products in a construction, and only 4 or fewer firms capable of producing for roofing cables and pipes. Also, there's 3 PVC and HDPE pipe producers, and then they account for 80%. When coming to energy, 50% of wind and solar power is generated by the top 3 firms. And the top 3 refineries and LPG suppliers have a share of over 65%. This is what the study has revealed. We're not going to go into detail, as I've indicated that this is just an excerpt from the report. If you really want to get the details of the report, you can go into the Competition Commission 2021, and then you'll get the report there, which is termed Concentration Tracker Main Report. There is a link there, down there, that you can go into, and then you'll be able to get more details insofar as the report is concerned. Now, coming to the definition of the SMMEs, according to the draft regulation, define the small, medium, and micro businesses in the context of the notice of the Competition Act, which means that small businesses, micro businesses, or medium-sized businesses, as defined by the Minister in Government Gazette number 987 of 12 July 2019. That's where the draft regulations also take the definition from, which is coming out of the Competition Act. Another definition of SMME, there are 2 metrics to legally determine the size of a business, which is the number of employees, full-time paid employees, or the equivalent of full-time paid employees. And secondly, total turnover. So how then the matrix is applied in 2 ways to determine the size of a business, a number of employees, as well as the total turnover, depending on the sector in which it is. So if you are in the agriculture, then there will be a specific turnover that you need to turn over annually, so that you can be classified as the SMME. Now, we've got the ceiling for employees across all the sectors. In terms of the micro enterprises, the maximum of 10 employees, and in terms of small businesses, between 10 and 50 employees, medium-sized enterprises between up to 250 employees. So that's a ceiling that has been determined insofar as the definition of the SMME is concerned, or if you need to be regarded as the SMME. Now, you can see in terms of each and every sector there. Agriculture, the medium size, the turnover should be 35 million, small will be 17 million, and micro 7 million. So those are the different sectors, and then depending on their size, that is the turnover that they need to make annually, so that they're classified as the SMMEs, in line with the definition, of course. Thank you. Advocate, thanks. Now let's look at Section 4 and Section 5 of the Competition Act, which deals with the agreement between or concerted practice by firms or decision by an association of a firm, which is prohibited between parties in a horizontal relationship. These include the exchange of commercial sensitive information. You'll understand if you've got the background of economics that when you talk about the restrictive horizontal practices, which are obviously prohibited in terms of the Competition Act. For instance, you'll have a supplier A, supplier B, and supplier C, where they've got an agreement, and those agreements lead to the Anti-Competition Act, where they've got the relationship which leads to the restrictive practices. This includes the exchange of commercial sensitive information among competitors, certain joint ventures, and certain agreements between members of the trade association, which have the effect of substantially preventing or lessening competition in a specific market. Also, these, unlike the cartels, parties to this horizontal agreement are allowed parties to this horizontal agreement are allowed to provide efficiency, pro-competitive or technological gains resulting from their agreements, which should be weighed against possible anti-competition effects thereof. I don't know if anyone wants to contribute on these horizontal practices, looking at the relationship of the suppliers, meaning that you are a competitor, for instance, in a particular sector, and then you agree in terms of the prices and so forth, you know, so that you limit competition in that specific market. Does anyone have, Dr. Advocate Nsaluba?
Look, this is a very sensitive and a very difficult ball to play, especially the sectors that you've referred to. In some instances, fortunately, I mean, the Competition Act is part of the place I play in. But we need to be very real about what is happening in this space, because you will find that it's not about price fixing. It's because of, should I say, the limited availability of those particular service providers. For example, let me talk about the artisanal small-scale mining sector. You will find that if you are going to do consultants in that space, you are not many. But you want them to mobilize efforts so that you complement each other. The question is, are you going to refer to that? And are you going to use the same clause? Let's go then, we go to the energy sector. I mean, we all know that there are so many opportunities that have been brought about within the renewable energy to be able to deal with SDG 7. But you find that in this space, there are not so many players. Now, the question then is, are we going to frustrate service delivery because we invoke that provision? So for me, we need, let me put it this way. I'm looking forward to us dissecting the regulations. And I'm saying it will be a sad day that the regulations begin to actually frustrate service delivery. Let me put it that way. So we need to sensitively look at these clauses in a way that they do not frustrate service delivery. And I'm not in any way saying there should be intentionally sabotage of the sector and closing off of the sector. Thank you, sir.
Thanks, Advocate Nsaluba, for that contribution. Anyone? Okay. Colleagues, you'll know that with the promulgation of SBD 9, in terms of, that stems also from the Competition Commission, that, you needed, when you are suspecting that there could be a possible anti-competition practices by the suppliers, maybe you find that the prices and so forth, you still need to continue, but with the evaluation, but report the matter to the Competition Commission. But by the time when and I'm coming to the point that advocate raised in terms of compromising the service delivery, you find that that by the time when you award, then maybe Competition Commission, it's only then that will come back to you with its findings. And then you have to now go through a process of undoing the contract, so that, based on the findings of the Competition Commission. So that in itself, colleagues, it does result in stifling the service delivery. So somehow we need to make sure that the bill or the regulations also come with the proactive way of ensuring that we are not going to stifle a service delivery. Thanks. Now we're looking at Section 5, which talks about the restrictive vertical practices, which is also prohibited by the Competition Act. Now, the restrictive vertical practices is an agreement between parties in a vertical relationship, and it is prohibited if it has the effect of substantially preventing or lessening competition in a market, unless a party to the agreement can prove that any technological efficiency or other proactive gain resulting from the agreement outweigh that effect. So you can see from the infographics there that you'll have your customer, the supplier A and B, maybe entering into this relationship in order to collude or in order to fix the prices, and then making sure that the customer thinks that the price are coming from the different suppliers. Now, this is the act between companies in a vertical relationship. For an example, a supplier and its customer that have the effect of substantially preventing or lessening competition in a specific market. I've alluded to the example. And then also the practice of prescribing the minimum resale price by a supplier or producer to its customer is also classified as a restrictive vertical practice. So those are the types of the restrictive vertical practices that are prohibited by the Competition Act, colleagues. Now, let's look into the draft in terms of the categories that are exempted from Section 5.1 and 5 and Section 4, I mean to say, and Section 5. Now, we spoke about horizontal practices which are prevented in terms of the Act, and we spoke about the vertical one. Now, the Act seeks to exempt the SMMEs from these sections in terms of the vertical and the horizontal practices which are prevented by this Act. Firstly, in a research and development agreement or R&D, which include outsourcing R&D to third parties or entering into a cooperation agreement to conduct research and development. Secondly, production agreements for the production of a good or the provision of a service, or toll manufacturing by one firm for another, or standalone or reciprocal basis. Now, production agreements is one of the category that has been exempted by the Act. Joint purchasing agreement, it's another one which may include collective purchasing by a subset of firms in a market or any other similar arrangement. Like, for instance, we know that when you're talking about the spaza shops, you know, the Pakistans are outweighing our traditional spaza shops because of your typical owners of the spaza shop in the townships or even in the urban areas are unable to sustain the competition from the price perspective. So what then the Pakistans are doing, then they come together and then make sure that they purchase collectively. So that is just one of the typical examples, but there are other examples that one can think of when you talk about the joint purchasing agreements. For instance, if you talk about the stock fares, so you find that in our stock fair setup also it's that kind of, we put money together and then come December we buy grocery. That is a joint purchasing agreement as well. That's one example that one can attribute to joint selling prices of goods or services to and through intermediaries defined under the draft regulation as business who deliver or otherwise sell another firm's product or service to customers or other business customers defined under the draft regulation as a customer that purchase goods or services for purpose of reselling or as an input into production by subset of firms in a market or any other similar arrangement. So colleagues, these are the categories or some of the categories that have been exempted from Section 4 and Section 5 of the Competition Commission Act. Okay, let's move on. Another category is commercialization agreements, and then standardization agreements, collective negotiations as well. It's one of the categories. Now, what is the implication of this draft bill to us as the SEM professionals? Now, you look in terms of the National Treasury, to both National Treasury and us as the practitioners, what are the implications in the SEM community? We've got SBD4 and to an extent also as MBD4, which may need to be updated, especially where it talks, paragraph 2.3, where it talks about having any interest in any other related enterprise, whether or not they are bidding for this contract. Do you think it warrants the change, colleagues, that paragraph, or it's something that it should stay based on the exemption from Section 4.1 and 5 of the Competition Act? And then also, if we go to the question that has been asked, if yes or no, if so, furnish particulars, how does the supplier understand and declare this? That's what we need to ask ourselves, colleagues. Have any interest in any other related enterprise, whether or not they are bidding for this contract? What is your take on this, colleagues? Do you think most of the suppliers will understand Tandi, and then Advocate Nsaluba.
You know, Malakia, the issue around interest is also very murky in terms of what is the understanding of an interest. But also, having worked with MSBD4 for as long as I can remember, service providers, yes, would declare this, and then what? What do we do with this information? Because it has always been like, for example, we'll look, maybe there'll be interest in a situation where somebody has had a contract elsewhere. But I found SBG4, we only look at whether somebody is in the service of the state or not. Any other information that is there is just merely for compliance, but do we collect it? And when we collect it, what is it that we do with it?
Yeah. As indicated, Tandi, this is a funny one, and I'm not sure what was I know we had a discussion about the SBD4. What was the intention of the Treasury in terms of, you know, including having any interest in any other related enterprises? You know, you might have the totally interest in two legal entities which are completely different. You might own a spaza shop and also own hypothetically a surgery. You know, I don't understand what is its significance in terms of you know, submitting a bid to an organ of state. Your spaza shop and having a surgery, you know, as a medical doctor. Perhaps this is one of the discussions that in our meetings we need to really make sure that we bring to the attention of the National Treasury. Advocate Nsaluba.
Thank you, Malaika. And then I don't want to disturb the stance that my colleague has taken. But I want us to recall that all these things are knee-jerk reactions to audit findings. And it is unfortunate that Treasury had to be put into a corner to end up with this because of audit findings. We might have a different debate, which then include the Office of the Auditor General and their interpretation. Because in my experience in the public service, that was helping to make sure that there's a same understanding of issues, both theoretically and even in the implementation space. I mean, I was blessed to be in the military space, where you needed to always make sure that your AG understands what you're talking about so that you don't end up with some findings. And I think it's high time that we do such engagement. And so I'm saying, Malaika, it must not only be with National Treasury only, we must put also the AG, because the AG seems to define what must be happening, which is supposed to be the other way around. And probably lastly to say, these regulations, I mean, the exemptions are quite exciting. And obviously they are actually ensuring then that some of the provisions which we have spoken about over time, they will need to be reviewed. But I don't want the review to be a sort of a knee-jerk. Hence, I'm saying we might need a session where the AG is invited to actually interpret and look at the whole package that defines procurement as a collective and analyze it the same way they came to interpret the actual court decision and its implication. Because if we do that, we're then dealing with the police and the person to be policed and us to be the beneficiaries to have the same understanding. Believe you me, if we do that, and of course, on the other side, then we have our PEE people who are custodians to also play a role, because this is about them. And I think we need that that set of people. And the question we're asking is a simple one. What's your own interpretation of this? What does it do to the existing legislation? What does it do to the industries that are supposed to be maximally utilized for the betterment of the citizens of the world? Thank you, Malaika.
Thanks, Advocate Nsaluba. There's also 3.3, which talks about the joint ventures. We must remember, colleagues, this also comes from if you recall, this was under the SBD 9, right? So now, is that the understanding of the block exemption that JVs and consortiums are not always needed for different agreements that will be exempted. Now, this is one of the questions that we really need to put at the back of our mind. But as it has been suggested that perhaps we need a National Treasury and AG to be in this room so that we can, in actual fact, raise this with them or let them assist us as the custodians of this of the Competition Commission, as well as the custodians and AG, I mean to say, as well, that they must come to this platform so that they can really provide some of the answers to the questions that we find ourselves having based on this bill. Let's move to the next slide. Thank you. Another implication for us, colleagues, is that do we as a practitioners understand restrictive horizontal practices as per the Competition Act? Now, do we need an economist to be in supply chain? I must say that most of us, and myself included, we might find ourselves not really having an appreciation of these restrictive horizontal practices or vertical practices in line with the Competition Act. Now, as you can see from the presentation, that probably not to the question that do we as a practitioners understand these practices. Yes, some of us might be aware of the issues based on our studies, but I don't think most of our practitioners will be able to have an appreciation of both restrictive horizontal practices as well as the restrictive vertical practices. Now, another question is that are SEM practitioners in a position to distinguish between exempt practices as per the draft and other collusive practices? It has been a challenge, colleagues, I must say, that you'll be told. I remember when I attended the training when the SBD 9 was introduced, we're told that you need to look at the same handwriting. You know, we need to look at, you know, the commas and the question marks, the punctuation. We need to look at, you know, then you'll be able to say that this bit comes from either the same companies, you know, but it's very difficult for one to determine that, you know. So the question now, which comes with this bill, is that are we able or in a position to distinguish between exempt practices as per the regulation and other collusive practices that are prohibited in terms of the Competition Act? Let's zoom into the further implications in terms of SCM teams. For instance, I spoke about suspicion of a collusive act, and not if, SCM teams should likely refer cases to the CC if there's a suspicion of a collusive act. I've alluded to this, colleagues. I don't think really we need to really spend much time on this slide. We can move. Thanks, Advocate. Now, another question here is, can SCM team, through enterprise development, been doing more to encourage this agreement and give some comfort to suppliers that this will not be regarded as a collusion? Another question, are there other possible collusive acts that should be included in a case of subcontractors? What about requesting a specific statement that Minister of the Department of Trade and Industry and Competition will work with the Minister of Finance to update the standard and municipal bid document, develop guidelines for SCM practitioners to identify the practices that the bill exempts, allow for at least 4 to 6 months period for preparation before the regulations are applicable. So these are some of the recommendations, colleagues. You are welcome to add if you've got a particular recommendation. What I've noted is that we need also to get AG and the National Treasury to also make us understand, more especially when it comes to SBD4, as is suggested by the bullet number 2 of the slide. What about requesting a specific statement that the Minister of the Department of DTIC will work with the Minister of Finance? Another slide, Advocate. Is that the last slide, Advocate?
Those are the 16 slides.
Oh, okay. No, thanks, colleagues. But on a hindsight, colleagues, there is another question that I really would like us also to give it a thought. You know, it's regarding whether this regulation, it's not in the presentation, but I would like us to note this, whether these regulations will entrust and legitimize the powers of the construction mafias. You know that the 30% guys, this all purport to be that purport to be the SMMES, and their collective effect has stifled the construction industry dramatically. You know that they go and demand 30%, and if they are not given that 30%, they will then disrupt the project. So will these regulations give them powers now to go and demand the 30%, and further, you know, stop the project if their demands are not met? And as the Advocate Nsaluba has alluded to the fact that what will the regulation do to the service delivery? Are we going to see more of delays insofar as service delivery is concerned? because of these regulations. That's food for thought, colleagues. It's something that we really need to think hard about. Yeah, from my side, let's open this for any questions, any comments. Ron?
Thanks for an excellent presentation. Just one point that I would like to engage with, and that's the role of the Auditor General. From what I imbibed, there seems to be a presumption that the Auditor General is an expert, and particularly an expert in this area. I beg to differ. The AG doesn't even get the basics right in supply chain management, and it's more the exception and the norm that they get the interpretation of law right. So generally AG staff are not trained in SCM, nor are they trained in law. I think they might have created a specialist unit of late, which has been long overdue. But the AG are by no means an expert in SCM. And secondly, is the AG need to be independent. So they can't be seen to be, they need to critically comment on these things. And I think there's a flaw in the process. I suspect, based on a conversation I had with a senior AG member a few years ago, that the AG does comment and does contribute to National Treasury. And that is a problem. Because then, you know, they say there's a Chinese wall within the AG, so this one section goes and comments and the rest don't. But the problem is that the AG, once regulation comes out, should be able to publicly criticize and state that these things are not in terms of the Constitution, are unlawful, have been overreached. And the mere fact that the courts take decades to now catch up when National Treasury makes mistakes. The second part, if I can just have liberties, is you've also had a presumption that National Treasury are an expert. And I think with all the missteps we've seen, particularly on National Treasury's legislative framework, and it's giving instruction notes that are ridiculous and then withdrawing them or changing them, and the fact that they're contradictory and all the rest of it, I don't know that National Treasury have the expertise, at least on SCM matters and anything relating to SCM. So, you know, that leaves a gap in the country in that who are the best practices body. And that's, of course, where the formulation or the development of a body that is a specialist SCM body. And the problem is that National Treasury were involved in the early days in formation of SAM, but I don't think National Treasury, again, have the expertise. And so there's a crying need for a group of experts, a panel of wise men in South Africa, drawing on international expertise to address key issues, not National Treasury or the AG. Thanks.
Yeah, thanks, Ron. That's a valid point that you are raising. Now, the question need to be how then, I think we need to, through this platform, be able to write to the National Treasury, and so that it gives impetus to the formation of such a panel, you know, where if Treasury, for instance, hasn't come up with a particular practice note or instruction note, that should also go to the panel for it to be ventilated there by the panel of experts, of course, and before it could be promulgated, you know. And this brings me to a point that advocate raised in our erstwhile forum, where she indicated that according to the Act or the Constitution, that there must be a consultative process. And we are still not seeing that consultative process other than, you know, publishing a bill or a practice note for comment, you know. And one doesn't get a feeling of what happens to these comments after they've been provided, you know. I saw another hand. Nandi? Oh, sorry, advocate. Then Nyasha.
Thank you. I think I agree with Ron. One thing I learned in the public service for years, that whether you like it or not, AG defines the game in the playing field. By just making sure that he's going to give you, of course, if you don't know your policies and laws, you will end up with those findings. And I'm saying, I'm looking at the regulations, and they are out for comments, colleagues. We need to spend time on Regulation 9 and actually check if Regulation 9 covers the whole lot of the space that we're operating in as SMMEs in terms of their agreements. There are also international agreements that you would find SMMEs engaging in. And my appeal would be that, you know what, there's no problem in writing a letter and then you get an answer. Let's make sure that we make everybody who must talk, and they must talk to us. Because at the end of the day, we are the ones who are going to be the victims of misinformation, small information, over large information, disinformation. I'm using these words carefully because I'm trying to cover everything that is as a function of the wrong interpretation of whatever is presented. You spoke about the 30%. And I want to say this. I participated in some discussion within the DMRE, and there was some work that was being presented there and there was a clause which interestingly was talking about them engaging with the community prior to the service provider taking its place, to inform the community that this is what has been agreed, and please, there must be no efforts. Sorry. There must be no efforts to distract the progress. And I was saying, look, we need a more stronger way of dealing with this matter. I'm linking with what you just said, the 30%. That's another form of the 30%. So I'm saying my plea to us is that let's use this forum, one, to even do the unimaginable, to call the authors of these regulations, to present to us what do they mean. And we make sure then that understanding is in line with the codes that we have, because at the end of the day, the understanding should be applicable across all sectors of the economy, without exception. So that would be my take. But also I implore us to also look at the regulations, regulation by regulation, and begin to ask our questions as SMMEs. What has been the worst scenario in terms of us participating? Secondly, if you look at JVs, I mean, I was working on some JV contracts recently. If you look at JVs across, and JVs are both domestic and international, it is Regulation 9 capturing all JVs. Lastly, if we go to the construction sector, clearly during the time when Minister Sulu was in housing, there was a way of making sure that the starting entrepreneurs and the people who have been in the field are meshed, so that there is sharing of wisdom, sharing of expertise, and sharing of everything. And it was a forced marriage. What do these regulations do to that? So I'm raising all these things so that when we look at this, we must look at it from a selfish perspective to make sure that we gain the best out of it. Last, and linked to that then, are the procurement pronouncements. Or surely most of them, they will have to be relooked. And I want to put here the role of accounting officers in ensuring that they are also part of the, like you said, the consultation processes and the CFOs, so that you don't have disinformation, misinformation, underinformation that derails the flow of processes. And I'm saying this because there are sectors that are critical now, especially the energy sector. There are critical things that must be done. You don't want those to be delayed because someone is hanging on to an SPD that has been revoked because of something. So I'm calling for more aggressiveness in terms of the forum, in terms of actually calling a responsible provisioning of the way forward once it is in the invitation of comments. And I'm telling you this because comments in entities are a function of who is available to write the comments, not who is available to present and have an understanding as an institution of what the piece of legislation is saying. I know this because I drafted regulations and I've been part of making sure that consultations across government are actually a way of domesticating of what is to come. And thank you, Malaika. I hope this is just the beginning of us engaging with these regulations. But we need to look at what these regulations are doing to other pieces of legislation. And of course, thanks to Sean all the time for actually making these opportunities. Thank you.
Thanks, Advocate Nsaluba, for those invaluable inputs. Let's go to Nyasha. And then
thank you.
Lindy West. Okay.
Thank you.
Nyasha?
My question is actually from an ignorant perspective. In your closing remarks, Malakia, you mentioned that, you know, what do these regulations mean for the construction mafia, if I can quote you directly. And in my mind, I was like, but those are, I mean, those are criminals, so to speak. And how do we incorporate regulation drafting with criminals in mind? So I just needed clarity really on how you meant that we should view these regulations with those in mind, the construction mafia who want 30% and etc. And what would these imply to them? Just clarify to me exactly what exactly you meant by that. Yeah, thank you.
All right, good question, Nyasha. I don't know, Tandy, do you want to respond to Nyasha? Okay, Nyasha, what I meant about these, right, is that, you know, you find in most cases that you've got it's not only one person that will approach a main contractor, for instance, to provide them with 30%, you know. Now, they come under the disguise of the 30% subcontracting. So the question is, are they also, what impact will this regulation or the bill have on them? You know, are we going to see them coming in and then being provided the opportunity now to even stop the project, you know, which is what is currently happening? Or will these regulations be something that will make them?
It's Tiani.
Yeah, I think in a nutshell, Nyasha, is that what will this regulation have, or will it make sure that it sort of maintain the status quo, whereby we'll see many infrastructure projects being halted because of the exemption, or what, you know? And hence I've said earlier on that this is a food for thought. You know, it's something that really we thought of. That's why I said on the hindsight, you know, I was thinking along those construction mafias, or the so-called 30%. I'm sure we'll have further engagement. There's been suggestion that we need to really invite the experts in the field. So I'm sure they'll be able to also answer this type of questions to us.
Yeah, I agree. Because I think that especially that specific aspect requires a different lens altogether, or an instrument altogether to deal with outside the supply chain, or outside the scheme, at least.
We don't want to say the treasury of commons. Now we are having this bill or the regulation, which will then, its intentions are good, but it will end up undoing some of the gains. So hence I'm saying we really, like you have said, we really need to invite the expert or the custodian of this regulation, which is DTI, or Competition Commission. Sis Lindiwe?
Thank you. Good morning, Tata Mashiloane. Mine is around, yes, mine is around the invitation of National Treasury to this platform. I think we've been saying this for quite some time now, and I'm sorry, I'm going to put you on the spot. You worked at National Treasury for quite some time, I think longer than me. Some of these instruction note or circulars, when they were drafted or issued, you were part of National Treasury, Tata Mashiloane. So I'm requesting you on behalf of the colleagues on the call that please use your networks at National Treasury to get people like Bo-Osi Mpho. Mpho is one of the people who's been at National Treasury for over 20 years. So we need people like her, people like Bubasani. I know you have connections with them. I do. I also have connections with them. But I just want to request that because of you were in a different unit compared to the one that I was in when I was at Treasury, please, in Tata Mashiloane, can you just use your influence and ask one of them to come and address, especially Mpho, because of I know for a fact that she is involved in drafting of the circulars and the instruction note. Please, in Tata Mashiloane, on behalf of all of us, thank you.
Thanks, Sis Lindiwe. I'll definitely do my best to get one of the Treasury colleagues to come to this platform and share with us their learnings as well, and their processes in terms of, passing this instruction note, practice note, and so forth. I know Sis Mpho, she has been there for quite some time. She's dealing with policies. Yes, you're quite right. Ron?
Thanks. I think in just 3 brief comments. The one is, it seems like the period for consultation expires in the next day or 2. So in order for us to look at this closely, it's not going to be very practical with the limited time and the other priorities. The second minor point, my third point is major. The second minor point is, it seems as if the Act also, or the draft regulations, state that those who wish to have exemptions must keep minutes. It doesn't speak about how we can have access to the minutes or have notification that they are, they are consciously doing that, because obviously one needs to identify SMEs who now are consciously applying this. If they are cutting up the market and doing these non-competitive practices, we need to know it, and that's not clear. There needs to be some indicator that they are deliberately splitting up the market in a non-competitive way. The third point, which I think is quite critical, and bear in mind, I've just read it briefly now after your talk, just to see what it says, is I'm not sure that a regulation can override the Constitution. So So what this regulation seeks to do is to exempt a particular category of supplier from the constitutional requirement to be non-competitive. Now, I then thought, but maybe it was using it in terms of historical disadvantage, but that's not what the Act says. It says all SMMEs, including those who may have been historically disadvantaged. So the Constitution is not helping. In fact, I think that if you want to pass this measure, it can't be dealt with at a regulatory or an Act level. It has to actually be dealt with at a constitutional level. Because you cannot use a regulation or an Act to contradict Section 217 on competition. And then clearly, by giving exemption, we are saying certain SMMEs can be non-competitive. Now, you can't say that. So I'm very confused as to why they think a regulation can override the Constitution. Thanks for that.
Valid point, Ron. Valid point. We don't want really to see what we have experienced with the preferential procurement regulation. So I think this really necessitates even more a discussion or a roundtable with the Competition Commission. May I suggest that in order to take this forward, that perhaps out of this discussion or out of this meeting, that we formulate a task team that will approach Competition Commission so that we can raise these issues, albeit that the due date for the submission of comment might be, is it Friday, you know? So my humble request that we formulate the task team. I don't know from Sean's side if that's how we should do things, but I'm sure we can formulate a task team that will approach Competition Commission in this regard. Dr. Advocate Nsaluva, I'm prophesying.
You are very prophetic. Thank you for
that.
And it will certainly come to pass before the end of this year because you've said it.
Amen.
Look, we really need to be proactive here. I think Ron has actually said what I didn't want to say. I said it politely to say the Competition Commission, because I wanted them to actually not only talk to the regulations, the process they took to developing, ensuring that the constitutionality and everything, precisely because of what Ron is saying. So I agree with you that there could be a working committee, of course, then subject then to final vetting by Sean, because he might be having other processes that he has in mind. But definitely, we want the Competition Commission to just do us a favor and come and present the situation. We want to understand, you know, and they contextualize them within the Competition Act. Not only them, the contextual, like what Ron is saying, because there are a number of issues that needs to be raised here in terms of even Section 4 and Section 5 of the Competition Act. Thanks. So I agree with you.
Okay. Thanks, Advocate Nzaluba. Colleagues, it's now 10 past 11, I meant to say. Can we then have volunteers? It could be maybe yes, Ron?
I appreciate the initiative of task force, but I don't think we have the time.
Okay.
I think the first thing is, and if this group is in agreement, that as a group we ask for the date to be deferred. so that, we can do this thing properly. We're not going to be able to do something that's reasonable by Friday. And I'm certainly hectic, so you're welcome to take any thoughts I've expressed on this forum and to include it in that content. But for me, the critical issue is we need to ask for the date to be deferred to apply our minds properly. Thanks.
Okay. I'm not sure, but the danger with that, Ron, they might come back and say, we've given you ample time, I know that we are only discussing this today, but they might come back and say, look, we've got enough submissions. So that is why I was suggesting that instead of, which is one of the things that will be discussed there, maybe in terms of deferment of the closing date for the submission of the inputs. I don't know, but it's just my thinking that they might come back and say they've got enough submissions and they know someone did not open the letter and so forth, and there'll be tennis ball game with all these things. So hence I'm saying if we get a task team, maybe write to the commissioner and say, Commissioner, would like to see you as a matter of urgency, Let's see, colleagues, who are in favor of the letter requesting deferment, so that it can give us an ample time to respond. And those who are in favor of us forming the task team. Advocate Mpaluva?
I think for me, these are not mutually exclusive. The letter could be one of the first things that the task team should do. As part of it could be part of the request to the commissioner that one of the matters is. I think our issue is bigger than just the deferment. It's bigger than that. So because they need then to spell out what are the issues, and the engagement with the commissioner is more urgent. And I think I'm saying this. Thinking of all the sectors that we are representing here and the agency. And you've been in government, I've been in government, what you've just said is so correct. It's very, very correct. We have a way of making sure that we move with whatever we have so that we finalize. So let's have an in-person engagement so that we could be taken seriously. Thank you.
Okay. We'll make a written submission wherein we request for the deferment and also request an urgent meeting with the commissioner and the team so that we can raise the concerns that we have raised today. Will that suffice?
I mean,
supported Dr. Mashiloane.
Okay. Ron?
Sorry, Legitimising, there you go, and I'll come in if you don't mind.
Come again, Ron?
Legitimising, go if you don't mind. I'll come in after her.
No, Ron, I was just saying to Malaika that I'm in support of his suggestion. Thank you.
Okay, so I just want to support the person who spoke, Nandi. I agree that we need to do both. So as a matter of urgency, we need to put in a written submission asking for a deferment. I don't think there's a necessity to have an in-person meeting. I think a written submission will be adequate. I don't know that the commissioner has time to meet with a number of the bodies, and I'm not sure that a physical meeting will be particularly helpful. But in order to give this punch, we need to have the appropriate legal rationale, and that takes time. Thanks. That's me for the day.
Okay. Thanks, Ron. Okay. In essence, we are saying that the letter should be written. I'll get hold of Sean, and then we'll craft the letter together that will be sent to the commissioner. Is that fine with everyone, colleagues?
With a time frame for response.
Okay, all right. Noted, Advocate. Colleagues, thank you very much for attending this forum, and I highly appreciate your robust engagement on this topic. And until we meet next week, thank you.